Ladies and gentlemen, we have a really great show today, and what we're going to be covering is FISA-702. And something that you may not have heard of from some of the other talk show pundits, and you're certainly not going to hear this from the fake news media. And today, instead of just calling them fake news media, we're going to prove to you that they are the fake news media and that we have been the pawns all this time. So today I'm joined by my trusty sidekick, Justin Allen Case. Justin, how are you doing today?
Absolutely fantastic. How are you, Joseph?
I'm wonderful. I am ready and excited to be on the Trump train and to expose what the globalists are doing and how they're doing it, and how, if you're not on the Trump train, you may have been manipulated. Now, I don't know about you, but I don't like to be manipulated. And I sure don't like to be punked by some fake news organization that has designed this to be this way. So we're going to prove to you, and you can do your own research, to find out what we're telling you is the truth. Okay, we have our first document here. Cody Snodgrass is a ex-CIA operative, and he has a book for sale, and we'll put a link to that book in the show notes. And this book has some awesome information in it. The book is 690, is that 98 pages?
I think so, yes.
698 pages long, and it is packed with great detailed information that you need to know. So let's get started with this. Justin, go ahead and turn to, flip through, I believe it's on page 17, and then we can blow this up and take a look at this. Now, in this book, to give you a little story about Cody, we should have a podcast up that we've had Cody on. Go ahead and expand that. There you go. And real quick, Cody was a CIA operative that was given the assignment to blow up the Murray building in Oklahoma City. Now, if you think 9/11 and the Oklahoma City building, the official story, if you believe that to be the truth, you're greatly mistaken. This has been an inside job. It's been set up, and our country has been hijacked from within. No country could take down America from without, but from within, different story. And thank God we've been able to stop that, and we've gotten a reprieve, but it's going to take us as Americans to get involved. You can no longer be a couch potato. You need to get involved and do the research. Now, we're going to lay the bread crumbs along the way for you to be able to find what we're talking about. Justin, why don't you go ahead and let's read this one page out of the 698 pages of Cody's book.
Great. This part is entitled CIA's Operation Mockingbird. In the late 1940s and through the 1950s, television was replacing radio as America's favorite media. Now in 2014, it's the internet, computers, and still TV. Back in 1948, Congress passed the Schmidt-Mundt Act, which authorized the United States State Department to disseminate propaganda outside the U.S., but specifically forbade it to do so inside the U.S. But not to be stopped by something like federal law, the CIA secretly began to penetrate our own United States media. In a covert domestic op, codenamed Operation Mockingbird. This was a fully implemented CIA op to plant disinformation in our U.S. media, a classic counterintelligence tactic to, quote, muddy the waters, unquote.
Okay, let me stop you right there for just a moment. One of the things that we're going to talk about today is the U.S. And when you see the term the U.S., United States, we're going to show you documentation. It's not what you think. It's been written in such a way that it's completely different, And that is why this FISA, Foreign Intelligence Surveillance Act, that's why this FISA Act is so damning on the American people. All right, Justin, go ahead. Keep reading, please.
Heightened Cold War tensions with Russia fueled the CIA's recruitment of American news organizations, journalists, and spies as propaganda pundits. These CIA media control efforts were headed up by Allen Dulles, Frank Wisner, and Washington Post's Philip Graham, a CIA director, Richard Helm. Declassified CIA documents reveal that their media assets included 400 journalists. Time, Newsweek, United States International, ABC, CBS, NBC, UPI, Copley News Service, Scripps Howard, Associated Press, Hearst Newspapers, Reuters, etc. During the 1980s, when this author was involved in some of the black ops in Arkansas and Nicaragua, the National Security Council's Office of Public Diplomacy, OPD, had officers from the U.S. Army's 4th Psychological Operations Group at Fort Bragg, PSYOPs, working hard. They planted stories in the U.S. media supporting Reagan administration's policies in Central America. Also, in 2000, this same PSYOPs unit worked in the news division of CNN's Atlanta headquarters, doctoring up stories during the final days of the Kosovo War. This author was involved in unrelated black ops at the CNN Center previously. This 4th Army PSYOPs propaganda activity, directed at American civilians, was reported by both France's intelligence newsletter and the Dutch newspaper Trouw. After this domestic covert CIA operation ran for many years, later on, then CIA Director William Colby testified to the Select Committee to study governmental operations with respect to the intelligence activities run by Frank Church in 1975. DCI Colby testified that over 400 CIA agents were active in the U.S. media to control reported content in American mainstream magazines, newspapers, and TV. So, unknown to the sleeping American people, subtle forms of mind control were already being set up covertly through the mainstream media. This form of hidden information, and thus mind control, was highlighted in Amy and David Goodman's recent book, Static: Government Liars, Media Cheerleaders, and the People Who Fight Back. They wrote, quote, among the chief executives who helped CIA were William Paley of CBS, Henry Luce of Time, Arthur Schulzberger of the New York Times, Barry Brigham, Sr. of the Louisville Courier-Journal, and James Copley of the Copley News Services, the leading TV networks including ABC and NBC, and the wire services, AP, UPI, and Reuters, along with Hearst newspapers, Scripps, Howard, Newsweek, and Miami Herald, and Saturday Evening Post. All had dealings with the spy agency. The CIA's most valuable associations were with the New York Times, CBS, and Time Incorporated. In 2013, the National Defense Authorization Act was passed by U.S. Congress. Hidden inside this act was the Schmidt-Mundt Modernization Act of 2012, which gave CIA even more power to propagandize the American public. This way, the shadow government operatives conduct illegal, covert, domestic black ops against Americans, like the Oklahoma City bombing. They will have plenty of mass media tools to control any blowback from their illegal operations. The power game is to control the information to keep the people ignorant, unaware, and in line. This way, ignorant civilian taxpayers are created.
Okay, let's stop right there. That's awesome. Now, ladies and gentlemen, this book, we purchased this book and we went through it to read quite a bit of it before we had interviewed Cody. And this story is amazing. There's also facts, figures, locations that is great to do research work with. And that's why we've labeled this the FISA-702 Ep.1, because we're going to do several episodes on this in order to bring you the facts of what's really out there and the fact that the media has been set up to lie to you. And every day when you're not paying attention to it in movies, in news, in sitcoms, it's all been programmed. Hollywood and Washington have gotten together to make you the mark.
Joseph, one of the things I think we ought to point out here, and it touched on it in what I just read there a little bit, but I want to make it very, very clear to our listeners. The United States is a corporation. It's a state in itself in the form of Washington, D.C.
Yes. Now, here's the thing that before, and this is very important for the listeners to understand, we're going to prove that to you today. We're going to show you the documentation. Now, look, we have in our show notes, and for guys on YouTube, you can see this. But there's probably 30 or 40 pages of information that we're going to provide to you in our show notes that you can go back and do the research. You can look at this, and you need to be able to put your eyes on this. The most important part of this is that you're aware of the facts, not the spin that the media gives you, but the facts. And you'll have the documentation in your hand that you can prove it. I'm sorry, go ahead, Justin.
Well, the other half of that is that because the United States is defined as Washington, D.C., anything outside Washington, D.C., or almost everything outside Washington, D.C., is foreign.
Folks, I thought it was way too important to let this go unchecked or just by adding some subtitles to this. What Senator Cornyn is proposing of the reauthorization of the FISA Act 702 is that we give up our privacy in order to have protection when we have history showing that it's been our intelligence agencies that have gone in and have created these false flags. Let's go to the tape.
President, as the subway attack in London last week proves all too well, when terrorism goes underground, it doesn't disappear. Every day there are individuals operating in the world's shadows in places like the Parsons Green Station in Fulham. They mean to do our allies and us great harm, and they're not going away. As President Trump said last week, in this era in which attacks like London are the new normal, we have to be proactive. We can't take our security for granted.
When he says our security for granted, is he referring to the same that President Bush said when George W. said, either you're with the terrorist or us? If you remember that hand gesture that he did. I believe Cornyn is saying the same thing. The American people have started to wake up to see the trick that's being done in Washington, and that we are the mark. And they are trying to protect them with this FISA 702. And there's some really interesting things that Trump has done, and we'll see that as we go a little bit further. Back to the tape.
We can't naively assume that when it comes to threats like that and others, even bigger, our country is out of the woods. And one way to be proactive and to keep our country safe is to reauthorize Section 702 of the Foreign Intelligence Surveillance Act.
Okay, ask yourself this question. Why in the world would Congress have meetings on video to the American public that we want to go spy on bad guys in Afghanistan, in China, some boogeyman someplace else, they wouldn't do that. They've never done that. They've never brought this to the American people. I believe this is the plausible deniability that they have now compromised all of Congress because they know beyond a shadow of a doubt what's happened. And they know, all of Congress knows now, that they're spying on the American people by wordsmithing this FISA-702 document. Let's go back to the tape.
Earlier this month, Attorney General Jeff Sessions and the Director of National Intelligence, Dan Coates, sent a letter to congressional leadership calling for this reauthorization. And it's easy to see why. Title VII of the Foreign Intelligence Surveillance Act allows the intelligence community to collect vital information about international terrorists, cyber actors, and other important foreign intelligence targets.
And of course, what our slick senator has forgotten to say is YouTube. They're spying on everybody, folks. And they know it, all of Congress knows it, and now the American people know it. And the important thing is, what are we going to do? Let's go back to the tape.
Information collected under one particular section, Section 702, produces particularly important foreign intelligence that helps prevent terrorist attacks and against malign state actors as well. And it does so by focusing on non-U.S. persons, which is important because this is, as it's called, foreign intelligence surveillance.
Well, now, hold on a minute there, Slick Willie. There's not a definition for non-U.S. persons. There's not a definition for U.S. persons. So, giving you the benefit of the doubt, which I probably shouldn't, in the definition of the FISA 702, subsection 1801, under definitions, United States persons is only mentioned 5 times. And by the way, there's no definition of a United States person there either. Okay, let's keep going.
It focuses on non-U.S. persons located outside of the United States who are foreign intelligence targets. But that's not all. Just as importantly, Section 702 also includes a comprehensive oversight regime to make sure the privacy of U.S. persons is protected under the Constitution.
Well, it's awfully big, John, to protect U.S. persons under the Constitution, considering that there's no such thing as a U.S. person. But they're protected under the Constitution, doggone it.
That's done by not only oversight here in the Senate and in the House through the intelligence committees, but also by the Foreign Intelligence Surveillance Court.
That makes me feel really comfortable. Really, I feel secure now that the FISA court is protecting me. Gee, what a laughing stock. You know, it's all a big game for these guys. It's all theater. It's all acting. Except they're acting with your life. They're messing with you. They think you're stupid. And they think that you're not going to do anything about this. This next clip is really disgusting. And this is exactly what I imagined that would go on in a FISA court. Or in any committee that they've put together. Let's go that tape.
What we are telling him to take into account. The decision, no, that's the implementing bill. We should be in the process earlier. Otherwise, it's another Obama rubber stamp initiative in the United States Congress.
Rubber stamp.
Mr. Chairman.
Okay, Senator Coates will be our...
Okay, let's get back to Cornyn. Talking about how great the FISA court is going to protect your rights. Here we go.
Which monitors compliance with the law. There's been some criticism of this provision, but I must say the overwhelming support that Section 702 reauthorization is quite remarkable in this polarized environment in which we live. Even the Privacy and Civil Liberties Oversight Board gave the program a ringing endorsement. But what criticism that has been made is actually based on very few actual facts and often reflects a misunderstanding, both of the purpose of FISA and the controls that constrain government action.
I've yet to see any controls that restrain government action. None. Who's doing it? You have Hillary Clinton, you have Obama. Why aren't they arrested? Why haven't they been indicted? You have Pelosi, McCain, Reid. I mean, the list goes on and on. This guy. Nothing happens. It's coming though. It's coming. And one of the things that I want to say a special thanks to is I appreciate that they've passed this last bill, because now they've been caught and it's all on tape. We'll see you at Nuremberg, fellas.
So when they say that they're not going to spy on United States citizens, they're talking about people in Washington, D.C., not the people in Texas and Oklahoma and New York and California and Wyoming. All of us living in those places are ripe, and we don't even know it.
Congress does not need to have some bill that they vote on in order to spy on some terrorist that lives outside of our borders. But they do if they're spying on us, trying to circumvent our Bill of Rights, and they're jumping outside of the constitutional box by doing this. So, Justin, tell us about what they're spying on.
They are recording everything every keystroke that we make on our computer, everything we say on our telephones. It's all a spy thing.
That's right. And this information about Carter Page that has come out, that he actually had worked for the FBI as a CI, which is a confidential informant, or some type of employee of the FBI, and then they turned around and made him a spy, and now he has the right to spy on everybody. I'm not sure I buy that line of thought, because they're already spying on everybody. That's the whole thing. Through your computer, through your cell phone, through everything that you do, you're getting spied on. Through everything. Your car is, if you have a modern day car, it is a data hub that's collecting information on where you go, how you get there, how fast you drive, the whole thing. And that opens up a whole new bucket of worms that we're going to get into some of those today. So sign up on josephfarleyshow.com. Now, we've also put together some other sites that's called NurembergTrials.tv, as well as True, T-R-U, viewsonline.com. So those are going to be other sites that we're going to expose this deep state. And make no mistake about it, ladies and gentlemen, we are winning this war for America. And you can get involved. Also, if you would like to help in our research and be part of our show, then you can sign up at me. So here's what you put in there. You just type me at josephfarleyshow.com. Send us an email. Let us know what your talents are. If your talents are research or communication of some type, if you like to write articles, if you're a social media guru, we want to hear from you, because this is going to take all of us. It's not just a few people. It's going to take the American people getting engaged in this. The new media is getting ready to be huge. So make sure that you sign up for the notes and follow us and sign up on our webpage. Justin, let's look at what our next item is here.
U.S. Attorney's Manual 3-2.110.
Okay, now one of the things that we wanted to show you while Justin gets this pulled up is that one of the other communist, and yes, I did say communist, one of the other communist organizations that has tried to overthrow America is the American Bar Association. And are we going to take grief about that? Yeah, we are, but I don't care. How about that? And all the other bar associations that are set up in each of the states. Because today we're going to show you where and how attorneys practice law. So we're going to explain to you today and show you how attorneys are licensed in this state. All right, let's look at this United States Attorney's Manual for just a moment. Justin, can you blow that up so we can see that better? All right, here's what it says about the United States attorneys. The United States attorneys serve as the chief law enforcement officer in each judicial district and is responsible for coordinating multiple agency investigations within that district. There are currently 93 United States attorneys stationed throughout the United States. So we need to find out where this United States is. Because you think you know. And that's the problem. When you think you know something, but you've never looked it up, maybe you don't know it. United States, Puerto Rico, Guam, the Northern Marianas. One United States attorney is assigned to each judicial district, with the exception of Guam and the Northern Marianas, where a single United States attorney serves in both districts. Justin, go ahead, read the history of this.
The Office of the United States Attorney was created by the Judiciary Act of 1789, which provided for the appointment, quote, in each district of a meet person learned in the law to act as attorney for the United States.
Okay, let me stop you right there. I thought they had to be licensed. I thought the Attorney General had to have a license.
Well, Joseph, most people think the same thing, but there are no such things as licensed attorneys in any of the 50 states.
Really?
Yeah, that's correct.
And you have documentation to back that up?
Absolutely. The Supreme Court in the case of Butchers Union versus Crescent City Livestock talks about exactly that, and they actually mention the practice of law specifically. They mention the practice of law, the practice of medicine, the preaching of the gospel, and tilling of the soil. But what they're saying is that no state can license an occupation of common right.
So I'm sorry, go ahead.
Most occupations are occupations of common right. I would say probably 99.5%, maybe more, are all occupations of common right and cannot be licensed by the state.
But somehow they've been able to do that, and that's what we're going to show the people today. Go ahead and keep reading the history here.
Whose duty it shall be to prosecute in each district all delinquents for crimes and offenses recognizable under the authority of the United States, and all civil actions in which the United States shall be concerned, unquote.
Okay, now wait a minute. I want to make sure that Jeff Sessions pays attention to this. Jeff, you got to get on the game, buddy. You have got to get in the game. You have the American people behind you, and there have been high crimes committed, and we need you to step up and get this done. Go ahead.
One stat 92. Initially, United States attorneys were not supervised by the Attorney General, parentheses, 1 Op. Attorney General 608, close parents. But Congress, in the Act of August 2nd, 1861, Chapter 37, 12 Stat 185, close parents, charged the Attorney General with the, quote, general superintendence and direction duties, unquote. While the precise nature of the superintendence and direction was not defined, the Department of Justice Act of June 22, 1870, parentheses, Chapter 150, 16 Stat 164, close parents, And the act of June 30th, 1906, parentheses, chapter 39, 35, 34, stat 816, close parents, clearly established the power of the Attorney General to supervise criminal and civil proceedings in any district. See 22 Op. Attorney General 491, 23 Op. Attorney General 507. Today, as in 1789, the United States Attorney retains, among other responsibilities, the duty to, quote, prosecute all offenses against the United States. See 28 U.S.C. Section 547, subsection 1. This duty is to be discharged under the supervision of the Attorney General. See 28 U.S.C. Section 519.
Okay, so now we're getting ready to get into the appointment of the Attorney General, and what you're going to find is that the President is the one that gets to select the Attorney General. Now, President Trump has done a tremendous job in selecting his people, and as he has gone through this, I don't think there's any, well, yeah, there is. There's the fake news media will tell you that he's done a horrible job. I think he's done a great job in allowing these guys to get out there and then show their true colors. But in the appointment at 3-2.120, appointment, it says United States attorneys are appointed by the President with the advice and the consent of the Senate for a 4-year term. See 28 U.S.C. Section 541. Upon expiration of this term, the United States Attorney continues to perform the duties of the office until a successor is confirmed. United States attorneys are subject to removal at the will of the President. See Parsons versus United States, 167 U.S. 324, 1897.
I want to bring up something that's a little far afield, but not too far, but I think it's important here. Along with the United States Attorney, of course, are jurists, and the highest panel of jurists is the Supreme Court of the United States. It is not necessary for any member of the Supreme Court of the United States, including the Chief Justice, to have ever gone to law school or ever passed a bar examination or been licensed, quote, in this state, unquote, by any state in the Union.
You know, it sounds to me, Justin, that there's a lot of similarities between Washington, D.C. and Hollywood, California.
Yeah, they're all make-believe.
Right. So as we get to this next section in this, as far as residents, pay attention to this part. So let's look at the residents. All United States attorneys must reside in the district of their appointment, except that in the District of Columbia and the Southern and Eastern Districts of New York. They may reside within 20 miles of their district. These provisions do not apply to the United States attorneys appointed for the Northern Districts of Mariana Islands, who at the same time is serving in the same capacity in another district. See 28 U.S.C. Section 545.
Just something very briefly here, Joseph, and we'll get into it in another thing, but the United States courts are supposed to be Article 3 courts if they're in any of the 50 states. Only one of them is, in fact, an Article 3 court. So I'm talking about Article 3 of the Constitution. Those are constitutional courts. Those are the courts that you and I, when we get hauled into federal court, have a right to rely on the Constitution and the provisions contained therein as our defense.
Okay, now wait a minute. Let's go back and clarify this.
Okay.
Because this is and ladies and gentlemen, we fall into this trap as well. And that is the very subtleness of a word. And that is, you don't have a constitutional right. The Constitution is a box that the administrators must stay in. We have Bill of Rights. So they've tried to confuse those to the American people to where they're really not sure what right they have at all. But what we have are Bill of Rights. Justin, go ahead.
While we're talking about that, this is going to go on another rabbit trail. Our rights come from our Creator.
That's right.
From God. They do not come from the government. They are not bestowed upon us by government. If they were, the government could take them away from us. The only person that can take our rights away from us, or the only entity that can, is our Heavenly Father, our Creator, God. And you'll find that in the second paragraph of the Declaration of Independence. We can go back to that at a later time, too. Anyway, the courts, the only one court is an Article 3 court, and that's the one in Hawaii. All the rest of them are Article 4 courts that were created under Article 4 of the Constitution. Those courts are made for Washington, D.C., and for its territories and insular possessions. There are two names of these federal trial courts. The first is District Court of the United States. That's an Article 3 court.
Now, let's back up for just a moment. When you say Article 3, some people don't even know what you're talking about. When you say Article 3, they don't know where you're pulling Article 3 from. So can you explain that, please?
Sure. Article 3 of the Constitution is where our court system, our federal court system, was set up. And it talks about the creation of the Supreme Court of the United States and inferior courts. And those are the courts that are supposed to be in each one of the 50 states. At the time it was created, the 13 states. But in every state they're supposed to be Article 3 courts. And in fact, what we have is Article 4 courts that are made for the territories, the insular possessions, the places that fall into the jurisdiction of the corporate United States.
That's right. So this act of 1789 that we're getting ready to pull up and discuss, you'll see how they've slowly kind of slid this in here. And when you're getting drug into the wrong jurisdiction, ladies and gentlemen, all of this is getting ready to get exposed. And people that have any type of criminal conviction where they did not have jurisdiction, your case can get overturned. Now, are they automatically going to overturn your case? Probably not. You're going to have to go through a lot of paperwork, but this is the tip of the iceberg of what's coming. Go ahead, Justin.
Well, that's really all I wanted to say. We could get into it in much more depth, but just for our listeners to know, this isn't something I'm just pulling out of my head. We have two Supreme Court case decisions on that. The first is Balzac versus the people of Puerto Rico. BALZAC versus people of Puerto Rico, and we'll have that in the show notes.
Okay. Ladies and gentlemen, also, the reason that we're doing YouTube presentations as well as podcasting, a lot of people can listen to a podcast as they travel back and forth to work. Or if they're traveling or going to the gym to work out or whatever the case is. But you can listen to this and then go to josephfarleyshow.com and get the show notes. All you have to do is register, get the show notes. You can pull them down, print them out, and you'll have this information. You'll be able to go to your friends and family and point to what we're talking about instead of some theory that you will probably forget a week from now. You'll actually have the proof of this. Justin, is there anything else that we need to look at, including authority of the Attorney General?
Well, just let me finish on this just briefly. Balzac says that the courts for the territories, Article 4 courts, are not really courts of justice, although they have the same authority in those territories that Article 3 courts have in the United States or in the states of the United States. The other case that we're talking about is Mookini versus the United States. That's Mookini versus United States. And that says the same thing in reverse. It talks about how the courts that belong in each one of the 50 states are Article 3 courts. Okay. Back to you, Joseph, and I'm sorry I took you down this rabbit trail.
No, that's fine. No, we're getting ready to compile all of this, and that's why you're going to need to go back and listen to this. Get it on your get it on your iTunes and listen to this over and over and over again. This is very simple, but it's very new for a lot of you, and you're going to have to hear this several times. We're also going to take this link for the United States Attorney's Manual, and that will be in the show notes. All you'll need to do is click on that link, and it'll bring this manual up that we have right here in front of you.
I'm sorry, Joseph, there was one other thing. I told you that those courts that are there are supposed to be district courts of the United States. Those are Article 3 courts. What you actually have installed in each one of the 50 states are United States district courts, not district courts of the United States.
Now, wait
and
a
those
minute.
are Article 4 courts.
They wouldn't try to confuse the populace, would they?
You'd be asking me for a legal opinion there, and I don't think I should give that. But hell yes.
Yeah, exactly right. Yeah, all this nonsense about, guys, you need to consult your doctor before you drink water or breathe air. I'm not an attorney. I can't give you any legal advice. Well, look, here's the thing. There's only one law, and that's it. So, and that is a heavenly law that the state bar or the federal bar cannot restrict, regulate, fee, fine, or fornicate. So that's very important for you to understand that. Something else that we haven't really asked the question, what is law? I mean, are you talking about the law of gravity? And if so, is there anything that overcomes the law of gravity? Well, how about the law of lift? Of course it does. So be very careful in listening to people. And see, the bar has done this, and I'll give it to him. Very, very, very intelligent. Not intelligent. Very crafty the way that they have done this. Because any corporation that's out here, corporate fiction, any corporation out here always has their attorneys that will sign off on something. Now, attorneys are officers of the court. They're unelected, part of the 3 branch of government, but they're unelected, and they're running America. So if you've liked the way America has run over the past 240, 250 years, then keep the attorneys. If you don't like the way America has run, then in 2018, we're going to get a chance to do something about that. And that's throw every one of those bums out of office there in Washington, as well as in the states that are career politicians. Because we're going to show you some stuff where they have tricked you, the public. They feed you, fine you, and you can look up the word fornicate you. All right, Justin, let's look at the authority of the Attorney General.
This comes in Section 3-2.140, authority. Although the Attorney General has supervision over all litigation to which the United States or any agency thereof is a party, and has direction of all United States attorneys and their assistants in the discharge of their respective duties, parentheses, 28 U.S.C. sections 514, 515, 519, close parents. Each United States attorney within his or her district has the responsibility and authority to A, prosecute for all offenses against the United States, B, prosecute or defend for the government all civil actions, suits, or proceedings in which the United States is concerned, C, appear on behalf of the defendants in all civil actions, suits, or proceedings pending in the district against collectors or other officers of the revenue for customs for any act done by them or for the recovery of any money exacted by or paid to such officers and by them paid into the Treasury. D, institute and prosecute proceedings for the collection of fines, penalties, and forfeitures incurred for violation of any revenue law unless satisfied upon the investigation that justice does not require such proceedings. E, make such reports as the Attorney General shall direct. 28 U.S.C. Section 547. Joseph, I think it's important here to mention that they are correct when they talk about this. There are laws that talk about revenue, internal revenue, if you will. But you notice they didn't mention anything here about the Internal Revenue Service. And the reason they didn't do that is because the Internal Revenue Service is not actually an agency of the United States. And the United States admits that if you pin them to the wall with it. The Treasury Department of the United States is set up in Title 31 of the United States Code. And starting with Section 300, it tells you how it's organized. And it's organized by creating the Customs Department and the Border Patrol and the Bureau of Printing and Engraving and all those types of things. No place in there does it say that the Bureau of Internal Revenue, which is the preceder of the or the Internal Revenue Service, is mentioned in the creation or the organization of the Treasury Department. So it's not a part. It's a civilian collection agency that is employed by, we believe, the International Monetary Fund. Okay, I'll go back to the text. By virtue of this grant of statutory authority and the practical realities of representing the United States throughout the country, United States attorneys conduct most of the trial work in which the United States is a party. They are the principal federal law enforcement officers in their judicial districts. In the exercise of their prosecutorial discretion, United States attorneys construe and implement the policy of the Department of Justice. Their professional abilities and the need for their impartiality in administering justice directly affect the public's perception of federal law enforcement.
Okay, Justin, let's do this. Let's go over to the Judiciary Act of 1789 and take a look at this. And we'll go ahead and have Justin blow this up on the screen. Now, guys, this is not a great copy, but remember, this is from the first Congress of 1789. Justin, go ahead and hit your green button in the upper left-hand corner. Perfect. And this is September 24th, 1789, Chapter 20. An act to establish the judiciary courts of the United States. Section 1. Be it enacted by the Senate and the House of Representatives of the United States of America in Congress assembled, that the Supreme Court of the United States shall consist of a Chief Justice and 5 Associate Justices. Now that's changed now. That's now 9. B. Any 4 of whom shall be a quorum, and shall hold annually at the seat of government 2 sessions, the one commencing the first Monday of February, and the other the first Monday of August, that the associate justices shall have precedence according to the date of their commission, or when the commission of 2 or more of them bear date on the same day, according to their respective ages. Section 2. And be it further enacted that the United States shall be, and they hereby are divided into 13 districts, to be limited and called as follows, to wit, 1 to consist of the part of the state of Massachusetts. And then it goes through and will describe the different 13 districts that they're going to use here. And this word district is going to be very important as we review the District of Columbia. Let's go down to Section 3. And be it further enacted that there be a court called a district court in each of the aforementioned districts, to consist of 1 judge who shall reside in the district for which he is appointed, and shall be called a district judge, and shall hold annually 4. Now, here's where I want to stop. I want to look at the footnotes where it says, A, the 3rd article of the Constitution of the United States enables the Judiciary Department to receive jurisdiction to the full extent of the Constitution, laws, and treaties of the United States. And that's what we're going to focus on, the word United States, when any question respecting them shall assume such a form that the judicial power is capable of acting on it. That power is capable of acting only where the subject is submitted to it by the party who asserts his right in a form presented by law. It then becomes a case. And that case that you ought to pull is Osborne et al. Versus Bank of the United States. Now, wait a minute. Bank of the United States? You mean they had a Bank of the United States before? Well, yeah, they did. They had several banks before we got overthrown by the corrupt Federal Reserve System. So it's Bank of the United States 9 Wheat 738 5 Rep 741.
Joseph, let me just point out here, because most of your people won't understand this. When they first started recording cases for the Supreme Court of the United States, they filed them under the secretary's name. And the secretary's name at that time was Wheat. And that's why it's the 9th volume of that secretary on page 738.
Yes, that's right. That's right. I'm looking at a case over here that is 7 Wall. That is one of the different names that you'll run across as you begin to look back in history, and you'll come across these cases. All right, C. The jurisdiction of the power of the district courts have been declared and established by the following acts of Congress. Act of September 24th, 1789. Act of June 5th, 1794. And then it begins to roll forward in the dates here.
District courts of the United States, and there is the United States District Courts. The United States District Courts are for territories and insular possessions, and they are brought about by Article 4 of the Constitution. District Courts of the United States are for the 50 states of the Union, and they're brought about by Article 3.
Well, folks, that's all the time we have for today. Please sign up for the notes and for future show information on our website, josephfarleyshow.com. Also, please subscribe to our YouTube channel and help share the links. We're in a fight for the very heart of America. We're being blocked by the globalists, the social media ghettos, and the fake news media, because here is where truth is revealed.